CR 012629. This is State of Iowa versus Scott Carl Pfister. This is the time and date that has been set for sentencing. The court will also hear all pending motions. Are the parties prepared to proceed? State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Let's begin with the pending motions. Mr. Schulte, you have some post-trial motions. Let's address those first of all.
Yes, thank you, Your Honor. Yes, we have filed a motion for a new trial and a motion in arrest of judgment based upon the verdict being contrary to the law and the evidence, and based generally on the proposition that based upon the record as a whole, no judgment can be pronounced. In particular, it is our position that the court should have granted the motion to acquit at the end of the state's evidence. At that point, the only evidence that had been produced by the state was the uncorroborated testimony of the alleged victim, who testified that improper sexual activity had occurred involving the defendant, but always in the presence of others. Second, the complaining witness waited for 10 years before making accusations. During all of those 10 years, she kept voluntarily placing herself, in fact, on many occasions almost forcing herself, into close proximity with the accused. Again, at the end of all of the evidence, the court should have directed a verdict. All the defense witnesses testified that they were present at the times when the alleged sexual activity occurred, and all of them said that they saw nothing, nor could anything have happened. Letting the jury engage in speculation and conjecture based upon such lack of evidence was clearly not correct, and the motion at the end of the state's evidence, and again at all of the evidence, should have been sustained. Thank you.
Thank you. Mr. Sprint?
Thank you, Your Honor. The state would resist defendant's motions in their entirety. The verdict was not contrary to the law, the evidence. The state did produce credible evidence beyond a reasonable doubt at all stages, but as the court knows, the state's to meet its burden through its case in chief before passing to the defendant. The state doesn't have to prove its case beyond a reasonable doubt. It just needs to put forth a prima facie case that, when taken in a light most favorable to the state, would allow for a jury to come back with that verdict. The state did that in this case. The state had eyewitness firsthand testimony, and as it relates to the speculation and conjecture, at the end of the defendant's case, the defendant's own words put defendant in the place and time, corroborated the testimony given by the state's witness, the victim in this case. So with that, the state would just ask that the court consider the record in its entirety, and would ask the court to dismiss the defendant's motions. Thanks.
Thank you. Anything further, Mr. Schulte?
No, Your Honor.
The court will deny the motions for new trial and motion for arrest of judgment. The court has previously outlined its rationale for denying the motion for judgment of acquittal. I would only state that the weight of the evidence, as counsel knows, is not determined on the number of witnesses or the length of time that any case takes to present. The weight of the evidence is a determination by the jury of what is the most credible evidence, and then determining whether there is evidence beyond a reasonable doubt. It is the peculiar and specific function of the jury to determine the credibility of the witnesses. The jury did so in this case, and once it had completed its determination of credibility, it had adequate evidence before it to reach the conclusion that it did. The court therefore will deny both motions for new trial and motions for arrest of judgment. Are there any other pending motions before we proceed to the sentencing? Mr. Schulte?
No, Your Honor.
Mr. Smith?
No, Your Honor.
All right. Let's proceed then to the sentencing. The court is in receipt of a pre-sentence investigation report and psychosexual assessment report. The pre-sentence investigation report was filed on September 1st, 2015. The psychosexual assessment report was not filed in EDMS and was presented to counsel in the court this morning. First of all, has the state received a copy of the pre-sentence investigation report and the psychosexual assessment?
It has, Your Honor.
Have you had a chance to review them?
I have, Your Honor.
Do you have any additions or corrections?
None, Your Honor.
Mr. Schulte, have you received copies of the pre-sentence investigation report and the psychosexual assessment report?
Yes,
Have you had a chance to review them?
I have reviewed the pre-sentence investigation report thoroughly, and I had a chance to briefly review the psychosexual report this morning.
Would you like some additional time to review the psychosexual assessment report?
No, I don't think that would be necessary.
Have you had a chance to review both of those with your client?
Yes, I have.
Does your client request additional time to review either of the reports?
I don't think so.
Do you have any additions or corrections to either the pre-sentence investigation report or the psychosexual assessment?
No, Your Honor.
Statement from the state.
Your Honor, the state doesn't have any evidence to present. The state's not calling any witnesses, putting the victim on the stand at the sentencing phase of this matter. The state would ask that the court consider the recommendations and findings set forth in the pre-sentence investigation, the recommendations made by the Department of Corrections, Judy Barton, and consider the psychosexual assessment report that the court had just previously mentioned. The state, Your Honor, is asking that the defendant be incarcerated. And well, the main reason, I guess, why we're here, well, not why we're here, but why there's even the possibility of defendant, why his going to prison isn't mandatory in this case is because in the jury verdict, in the instructions that the state had put together, did not include a special interrogatory that distinguished between one of the two theories of the sexual assault statutes. The state believes, and I think the record reflects, that the jury could have found that the defendant either engaged in a sex act with the victim while he was related and while the victim was of a certain age. That all notwithstanding, regardless of whether or not defendant, whether it was a crime of a nature that required he go to prison, the facts of the case, defendant's history, the findings as set forth in the PSI all demonstrate that defendant needs to go to prison, and he needs to go to prison for the following reasons. While he continues to deny his intent or the facts as they came out during the case, it has become abundantly clear that the only way to protect society, protect children that have acquaintance with the defendant, is for the defendant to get treatment. This same exact scenario played out 10 years before, in around 1995, with another relative. Defendant was convicted of that. Defendant, although it was a crime that was sexual in nature, was not required to go through sex offender treatment. Now, armchair quarterback, looking back, things could have been done differently. That was a long time ago. But I can't help but think, Your Honor, that had defendant gotten treatment at that time, that we wouldn't be here. And we can't go back in time. And what happened has happened, but it doesn't have to happen again. The rehabilitation aspect of the prison sentence is probably the most paramount concern for the state. Without that, it's not I guess history would tell us in this case that it's gonna happen again. And last, Your Honor, I'm not gonna go into great detail because His Honor presided over the trial, but the nature of the offense committed. Defendant took advantage of a young girl, his niece, who looked up to him, took the innocence, and the defendant can describe it as he had a crush on her. Even if that was the case, which I don't think it was, it doesn't matter. She's a little girl. He knew better. He took advantage of that. And, as the court can see today, we have two families on both sides. They'll never be the same. Their familial relationship will never be the same. It's destroyed. His conduct is not just taking the innocence of one girl, two girls, three girls. It's destroyed his family. It's completely obliterated any sense of family and love, and he'll never get that back. And it's all because defendant's selfish acts. So the state doesn't relish sending people to prison. In fact, I think as the court knows, it's the last thing that my office considers. Because prison's not easy. And it doesn't always serve the best interests of the state, of the community. But in this case, there is no other alternative. It is not safe for the defendant, without being rehabilitated, to remain in the community. It's just not, I don't enjoy being here. I know the families don't enjoy being here. But it's the only viable option as the state sees it, Your Honor. And I guess with that, I'll rest.
The court has not received any victim impact statements. Is the state aware of any victim impact statements?
Your Honor, there are no victim impact statements. Insofar as it's relevant to the sentencing proceedings, the court would just ask, or the state would ask that the court just take notice of the testimony of the victim, as well as the minutes of testimony in the original trial information in this case, noting that there was multiple victims. Even though that wasn't tried, wasn't proven, the state just asked that the court take notice of that.
Mr. Schulte?
Your Honor, I have some people who would like to testify.
All right.
I would call Donna Jessen.
Please step up. When you come up here to the stand, if you would raise your right hand, please. Do you solemnly swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Thank you.
Thank you. Please be seated. Please state your name for the record,
Donna Jessen,
and would you spell your name, please?
DONNAJESSEN.
Thank you. Mr. Schulte, you're with us?
Donna, how old are you?
42,
Where do you live?
in Wall Lake.
What is your relationship to Scott Fisker?
He's my brother.
Were the two of you raised together?
Yes,
Are you married?
I am.
Do you have children?
I do. A boy and a girl.
What's the age of the boy?
14.
And what's the age of the girl?
My daughter's 16.
Over the years, even after you have been married, have you maintained a close relationship with Scott, his family?
Yes.
Have you been to his home and they to yours over these past few years?
Multiple times.
Have you ever felt any inclination to need to protect either of your children from Scott?
No. Him and his wife used to babysit our kids.
Were any problems ever brought to light?
No.
Would you, even after all of this, have any hesitation in, say, letting Scott care for your daughter?
Absolutely not.
What is your general impression of your brother?
He's a great father, a great son, a great brother. My kids love him. They love going to his house.
Does he work hard?
Absolutely.
Has he always supported his family?
He has.
Do you believe that in any way, shape, form, that he represents any type of threat to your family or to the community?
Absolutely none.
Is there anything else that you would like to say on Scott's behalf?
Other than the fact that I know he's innocent, we have spoken with our kids about this. We have questioned them, not because we felt he was guilty, but in the situation, you always ask. Our kids love their uncle. They continue to want to go see their family over there, including him. And I would never hesitate to leave my daughter alone with him.
Okay, I have no further questions.
Mr. Smith,
Nothing.
you may step down, thank you. Next witness.
We'll call Christie. Christopher.
Please raise your right hand. You solemnly swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please be seated. Please state your name for the record.
Christie Pfister.
Thank you, Mr. Schulte.
Christie, what is your relationship to Scott?
I'm his wife.
How long have you and Scott been married?
Been married 25 years this year.
What, generally speaking, has been Scott's position in your family, in your household?
He's our rock. He's our nucleus. We all kind of revolve around him. He's, you know, my boys are grown. We still turn to the dad for advice, for guidance. His mom and his sister both have great husbands, but when things are tough, Scott's the one they turn to. He's always there for them.
Now, we know you and Scott have the two boys because they were at the trial.
Yes,
You also have a daughter, is that correct?
right.
How old is your daughter?
She just turned 14.
And what is the relationship between Scott and your daughter as far as you have observed it?
They have a great relationship. They have a very alike personalities. They get along great. They joke. They laugh. She's definitely a daddy's girl. She loves her dad a lot, and all his, you know, they have a very close relationship.
To what extent does Scott contribute to the finances of the family?
We both work full-time, but clearly his income is higher than mine. You know, it's anywhere from, maybe not double, but what my income is, but probably close to it.
What type of impact will it have on your family if he is no longer allowed to specific ideas as to what life would be like without his income?
What I make will barely support Sam and I.
And Sam is your daughter.
Yes, I'm sorry. I'm not sure that what all we'll be able to keep. We have to downsize considerably, and I'm not sure how much we could keep. The boys would have to move back in to help support, which is not what I want. They're grown boys, and I want them to have their own lives, but I'm not sure that we would have an option.
How would you describe the strength of your marriage at this point?
We've always been good. Just the two of us gets the world kind of thing. We both have had hardships in our life, and we just have always turned to each other for strength and love and understanding.
And even after all of this, would it be your intention to stay with Scott?
Absolutely.
Has any of this in any way diminished the way you feel about him or the strength of your relationship?
No, it probably has made us tighter, more supportive, just trying to be there for each other and, keep our family together and support it and making sure that our kids are okay.
Would you be supportive of Scott if the court were to allow him to enter into an outpatient sexual offender program such as is offered in Fort Dodge?
Absolutely. Quite honestly, we need him. If he goes, prison is a ending for us. We need him in our daily lives in more ways than one.
Thank you. I have no further questions.
Mr. Smith?
Thank you, Your Honor. Do you believe your husband's innocent?
I do.
Do you believe he has any sexual deviancy issues?
No.
So the question that was just asked of you by Mr. Schulte, that you would support him in his efforts to rehabilitate in
If
Fort
that's the
Dodge.
only option I have, what else? If the only options you're giving me is either he goes to prison and goes through this course, or he goes to the outpatient in Fort Dodge. Right now, there is no other option. You're not giving me another option. No, I don't believe that he did this, but
Do you believe he should have to go through sex offender treatment?
if that's the only option that you're giving me,
My
that's what
question-
I'm taking.
My question was, do you believe that your husband should have to go through sex offender treatment?
Because he didn't do it.
Do you believe people should be held accountable for their actions?
Yes. That is something that we've always been very supportive to our kids, that,
If the jury let me ask you this, if one of your children were the victims of molestation, and a jury, duly impaneled jury, convicted that person, would you want them to go to prison?
I can't answer that. I'm not in that situation. How can I judge that?
What would you want to happen to a person in that situation, to a defendant? Somebody convicted of molesting your children, what would you want?
Justice.
And justice to you would be what?
To make it right for everybody.
And how would they make it right for everybody?
I don't know. I don't know what you're asking me, I guess.
It was a hypothetical, and the hypothetical is as follows. One of your children is molested, the person who did it was convicted of it by a jury. What would you, as the family, the mother of the victim, what would you want for that person, that defendant?
I guess I answered, justice, but I can't answer. I can't. I don't know what you want me to say.
Anything further?
Mr. Schulte?
Nothing further.
Thank you, you may step down.
I call Mike Penniman.
Please raise your right hand. Do you solemnly swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please be seated.
You bet.
Please state your name for the record and spell it for the record.
It's Michael Penniman, and it's Penniman.
Thank you, Mr. Schulte.
Mr. Penniman, where do you live?
I live in Sac City.
Where do you work?
I own a business over in Lytton.
How long have you owned that business in Lytton?
Mid-70s, I went to work for Fred Williams. And in 1990, I bought the business, and I'm there yet.
Can you explain to us what the business is?
It's a retail business on livestock equipment where we go ahead and repair and sell new, and it's livestock equipment.
What's the name of your business?
Lytton Farm Equipment.
How many employees does Lytton Farm Equipment have?
At the present time, I got 3.
And is Scott Pfister one of your employees?
Yes, he is.
How long has Scott been employed by you?
Since September of 13.
And just to go into your background a little bit, you state you live in Sac City, your business is in Lytton. Have you pretty much lived in this geographical area most of your life?
Yes, I have.
And what has been your involvement in the community affairs?
Well, I joined the fire department in 1985, become just a firefighter, and then I advanced up to a captain, and then to an assistant chief, and I retired out of there as fire chief. And I had 9 years of sheriff reserves here in Sac County. And I'm on the cattlemen's, Sac County Cattlemen Board. I am a board member and been a board member for 29 years. I am the treasurer of the Sac County Cattlemen right now. And I do 4-H things, whatever it takes to be helping.
Now, can you describe what Scott's duties are at your company?
Yes, he's the shop manager. He repairs all call-in repairs. He puts the machinery together for me. He does an awesome job, and when it's not done, he stays till it is done. If I need to have him on Sunday morning, he comes in on Sunday morning. So, you know, he's valuable to me, and I've been in the business, you know, for 40-some years. And I just know without him, it'd be a hardship for me. And I really honestly think that he's safe to our community. And I just, you know, and my company is a Better Business Bureau A+ member. And it goes back to me and my health. It ain't just me that makes me an A+ member of the Better Business Bureau.
If you had to replace Scott suddenly, Do you have anyone trained and ready to step into his position at your company?
No, I do not.
How would his removal from your company impact on your business?
Oh, it would be sizable in my income because I depend on him to make me a Better Business A+ dealer. So it would make a big impact on me.
You stated that you don't have any fear for the community in general, or for anyone else for that matter, if Scott were allowed to remain outside. Is
I
that
don't,
correct?
yeah, I don't have no issue with that. In fact, I would go as far as being a mentor, if that's the case, for him. I guess that's how much faith I got in what I think he could do.
Okay, thank you.
Mr. Smith?
Yes, thanks, Your Honor. Is it Penniman?
Penniman, yes.
Penniman, Mr. Penniman, sorry. Have you talked to Scott about this case at all?
I have not. We went up to the Clay County Fair yesterday to set up our business because we got a display up there. And on our way home, Scott asked me if I would be here today. And I told him I certainly would.
You never talked about the case with him?
Never have talked about the case whatsoever.
Do you know
I read it in the paper, but that's all I've had.
So you're familiar with the nature of the allegations?
Yes,
You're familiar with the fact that those allegations were then adjudicated and the jury convicted Scott of committing a sex act with his niece?
yes, but I guess my opinion is probably different than what maybe the.
And that's fair, everybody's entitled to their opinion.
Yeah, so, I mean, I did know what he did, or what they charged him for, because I read it in the paper.
And what's your understanding of that?
What's that?
What's your understanding of that? What he was charged with, what you had read in the paper?
Well, I guess I'm not sure what the classification really was. I don't know if it said, I can't remember what it said, but I just don't understand, I guess, if, as you read before, the state had proved that he needed some kind of guidance. If that's what he needs, let's let him stay working and help his family survive. And
I'm just asking you a question. You testified that he's not a danger to the community. You don't know,
I guess I don't know what he does when the doors are shut.
and that's kind of where I was going with that. So,
Okay, I guess I don't know that.
are you aware that the defendant was convicted of, was charged with a similar crime in 1995, subsequently pled guilty to a lesser offense, and that offense involved a relative that was younger. Are you familiar with that?
I have heard it, but I'm not familiar.
And what have you heard about it?
That it was just a deal. It wasn't, I guess what I want to say, it wasn't sexual.
That's your understanding of it?
That's my understanding.
And how did you come on upon that understanding?
I guess I don't know how I would quote that, I guess.
Sure. So, just your testimony earlier was that you don't think that your best employee is a danger to the community, right?
I don't, just knowing him when he comes to work and being around us, and I don't.
Sure. So you have no reason to disagree if in fact he was convicted in 1995 and was convicted just a couple months ago.
Yeah, I can't go ahead and I guess I don't know.
Sure. Mr. Penman, do you believe people should be held accountable for their actions?
Well, yeah, I think person should. I don't believe in that kind of a deal, but I just still don't think that it was, this is my opinion. I don't think that he was guilty.
Sure.
That's all I guess in my mind I got.
Did you come to trial?
No, I did not.
And you really don't know any of the facts of the case,
No, sir.
but your opinion is he's not guilty.
Well, I guess talking to the community and they see it on the YouTube and all that stuff, I don't think, I've had a lot of people go and read that or see that, and they think he was railroaded. That's just my opinion.
And everybody's entitled to that, sir. Thank you.
Yes, sir.
I don't have any other questions.
Mr. Schulte?
Just to reiterate, you don't have any fear for the community if Scott was allowed to continue to work for you.
No, I wouldn't.
And his job is not only available to him, but you're asking that the court give that serious consideration.
I would sure like that, just because of the family, my hardship, and everything about it.
Okay, I have no further questions.
You may sit down, sir. Thank you.
No further evidence, Your Honor.
Statement.
Yes, Your Honor. The pre-sentence investigation report and the psychosocial evaluation that were done lead to a conclusion that Scott needs treatment. And they then go on to say that based upon the psychosexual evaluation done, the treatment would better be performed at Mount Pleasant. The whole thrust of the pre-sentence investigation report, and again of the psychosexual report, is treatment, and the place that they believe the most intensive treatment occurs is at Mount Pleasant. The only problem with that is that Mount Pleasant is also a prison. And it takes the defendant out of the community. It takes him away from his family, whom he supports in financial as well as emotional ways. The psychosexual evaluation makes a couple of observations during the brief reading that I had of it this morning. And one of them is that he has a type of personality which would not be particularly amenable to long-term incarceration. That a period of short incarceration would probably be enough to impress upon him the importance of always behaving correctly. The second thing it does say, however, is in the section on the propensity to reoffend, the risk has been calculated through these various tests. The composite risk comes somewhere from low to low moderate. Based upon the fact that Scott is needed at home, he's needed by his employer, and he presents what the psychosexual evaluator says is a low to low moderate risk, I would ask the court to consider not imposing a period of incarceration. The other thing I'd like the court to consider is this. There is a program, as the court is aware, in Fort Dodge, a long-term outpatient sexual predators program, which deals with situations such as this for the Department of Corrections, for the juvenile court, and for other purposes. He has not been evaluated by any staff from that particular program. And I know their sexual offender program is long-term and is intense. Bearing in mind that that is available to the Department of Corrections I would ask the court to seriously consider that. Also, I would ask the court to consider that in the light of the two conclusions drawn by the psychosexual assessment relating to the amenability and the advisability of long-term incarceration as having an effect, and the fact that we're talking to low, moderate risk of recidivism. I don't think that allowing him to participate in an outpatient program in Fort Dodge would also be contrary to some of the other goals of sentencing. Certainly, safety of the community is one of them. His getting treatment can't do anything but enhance the safety of the community. His being on probation can do nothing but enhance the safety of the community. The fact that he will unfortunately be placed on the sex offenders registry as a result of the conviction enhances the protection of the community. It also serves his rehabilitation. And according to the psychosexual evaluator, it probably contributes to his rehabilitation more effectively than some type of long-term incarceration. Of course, there has to be a consequence. That's part of the sentencing process. The consequence to Scott has already been felt. The devastation that this whole process has caused to the family has certainly been painful for him and for everybody else. The placement on the registry is punitive. Being forced to follow certain strict rules of probation is to some extent punitive. But I think that a program of outpatient treatment can be developed, supervision can be imposed, the community can be assured of safety, and all of that can be accomplished without the heartbreak of sending this father and husband away from a family that loves and needs him. So I would ask the court to give that serious consideration. Thank you.
Thank you, Mr. Schulte. Mr. Pfister, this is your opportunity to tell me anything you want me to consider prior to passing sentence.
Growing up, I didn't have a decent father, and I told my wife when we met that I would, if we had children, I would be there for my children. And going to jail takes me away from my children, and I can't do what I'm supposed to do, is be there for my family. That's why.
Anything else you'd like to say, sir? Anything else from the state? Mr. Schulte?
No, Your Honor.
Mr. Pfister, to begin with, I want to make something very clear. I am not considering the fact that you have not made some admitted that this happened, or that you are maintaining your innocence in any way in sentencing you. That is your right, and I'm not considering that. Secondly, I'm not considering any uncharged offenses that may be described in the pre-sentence investigation report or counsel or in the psychosexual evaluation. Those have not been proven. Those have no effect on my decision. The goals of sentencing are threefold. First of all, rehabilitation. Secondly, deterrence. Third, incapacitation. What does that mean? That means that my goal in creating a sentence is to find the sentence that is most effective in rehabilitating you, deterring you from committing additional offenses, deterring others who might look at this case and see what penalty they might receive. And in some cases, incapacitation is necessary. Generally, incapacitation is reserved for those who have a lengthy criminal history and have proven that they cannot exist in society safely. Your case, unfortunately and uniquely, has some of that incapacitation element, which I'm going to discuss in a second. It is important to keep in mind that there's a prior offense. What does that tell me? The prior offense tells me that probation was not successful. Now, I understand that you did not receive any counseling or rehabilitative services regarding this matter. But it tells me that strictly the fear of going to prison or jail, while that may have expired when this occurred, was not sufficient to change your course of conduct. Let me say something else. While I do not take into account or hold against you maintaining your innocence, I have accepted the jury's verdict in this matter. They have made a finding of fact, and I have accepted that this event occurred. So when I evaluate what the appropriate sentence is, part of my rationale is that this event has occurred, and that a jury of 12 people, and listening to the evidence, have made that determination. There is a need for intensive treatment for your rehabilitation. Mr. Schulte has quite eloquently outlined an alternative which would involve outpatient treatment. I do not believe that that is adequate for you. I believe, and I agree with the recommendations of the pre-sentence investigation report and the psychosexual assessment, that you need intensive inpatient treatment to deal with this issue. Secondly, the safety of the community. Witnesses have testified in your behalf about your value to your employer and your family, and I'm sure your friends. But the nature of this offense demonstrates a repetitive and reckless disregard for the victim. Part of the testimony, or some of the events that were placed into evidence, and indicated or established that some of this abuse occurred in the presence of other people in a secretive manner. And I'm talking about in your own living room, in the duck boat. The very nature of those events demonstrates either a desire for the events to occur among other people with the threat of detection, or complete disregard that it occurs in that manner. In either event, that manifests an unsafe situation. And I believe that the doctrine of incapacitation comes into play. Until you receive rehabilitative services, and until it's determined that you are rehabilitated, you are a danger to the community. You are a danger of recommitting the offense. Let's talk about the need for deterrent impact. This is where the prior offense becomes relevant. Your offered plea in that case, and a determination by the court in that case that your plea should be accepted based on the weight of the evidence, the sentence that was given by the court completely failed to deter you. If probation would be given today, aside from a requirement that you engage in treatment, there would be little difference between what happened then. As a result, I conclude that probation is not sufficient. The threat of going to prison or jail is not sufficient. It is time for you to go to jail. It is time for you to go to prison. Perhaps that, rather than the threat, will be sufficient when you're released from committing additional offenses. It will be the order and judgment of the court that the defendant be sentenced to the custody of the Director of Adult Corrections for a period not to exceed 10 years. Deputy, would you please remove the disruption from the courtroom? The court needs to also clarify the fact that as the state and defense have agreed, the court cannot make a determination of whether this was a conviction under the forcible felony element of the statute that was presented to the jury. Therefore, the court will render sentence based on a non-forcible felony conviction. The court will impose the mandatory minimum fine of $1,000 and the 35% surcharge. Is there any victim restitution?
No, Your Honor.
Mr. Schulte, do you have any idea what your fees are today? Or were you court appointed or were you privately retained?
No, Your Honor, I was court appointed, and there's a fee cap, but it was lifted and expanded, and I believe it's got to be less than $5,000.
What is the fee cap?
The regular fee cap for SC, I believe, was $2,500, but we have, the state has lifted the cap, I think, to $5,000, but I'm not sure of that. But it will take us a while to calculate the entire fee.
Mr. Pfister, do you have the ability to pay any amount of attorney fees?
Not this time, not without working.
I'm not going to impose any liability then for restitution for court-appointed attorney fees because this sentence involves incarceration. The court has heard from your family, your employer. The court does not see any additional source of income for you. The court will not make an imposition of restitution for court-appointed attorney fees. Now, this has been determined to be a Tier 3 sex offense. This requires you to register with the sheriff in each county where you have a residence, maintain employment, or are a student within 5 days of sentencing or upon your release. And that's an ongoing responsibility. So if you change your employment or residence, you have to register. There is a registration fee of $25 that begins with the initial registration. It is a criminal offense, a separate criminal offense, to not register. It can also be a violation of the terms of your release. Just make sure that you register. There is a civil penalty pursuant to Iowa Code Section 692A.110, subsection 2, of $250. You must present a sample of DNA for DNA profiling. You must also provide a fingerprint sample. Now, pursuant to Iowa Code Section 901.5, subsection 13, and 903B1, you are also sentenced to a special sentence, which commits you to the custody of the Director of the Department of Corrections for the rest of your life, with eligibility for parole as provided in Chapter 906. The special sentence will commence upon completion of this sentence that I have just imposed, and it will continue as if you are on parole. You will be required to register on the sex offender registry for a period equal to the term of the special sentence, pursuant to Code Section 692A.106. There will be a no contact order involving the victim of the offense. What is the time period of the no contact order? 5 years?
It's 5 years, Your Honor.
5 years. And before I give the appeal rights and the appeal bond, is there anything else concerning the sentence? State?
No, Your Honor.
Defense?
No, Your Honor.
Mr. Pfister, you have a right to appeal this judgment and sentence. Appeal can only be taken by filing a written notice of appeal with the clerk of court within 30 days. Failure to timely or properly file the appeal will result in a waiver of your right to appeal. So if you want to appeal, don't waste any time. Appeal bond is fixed in the amount of $15,000 cash only. That only applies if you want to avoid the imposition of this sentence while the matter is on appeal. Mr. Pfister, I wish you luck, and I hope this is the last time that you're involved with the court system. Anything else?
No, Your Honor.
No, Your Honor.